Welcome to Representing Victim Voices, Courtroom Animal Advocate Programs. Thank you so much for joining us today. My name is Kathleen Schatzman, and I am the Strategic Legislative Affairs Manager at the Animal Legal Defense Fund. Now I'd like to introduce our speakers. David Rosengard is a managing attorney in the Animal Legal Defense Fund's Criminal Justice Program, where he works with stakeholders across the criminal justice system to pursue justice on behalf of animal cruelty victims. David helms the Animal Legal Defense Fund's groundbreaking work, helping animals who've been harmed by criminal cruelty achieve legal status of crime victims, including efforts to expand courtroom animal advocate programs, which allow pro bono attorneys and law students to act as counsel for those animal crime victims in court. Jessica Rubin is the director of the University of Connecticut's Law School Animal Law Clinic, professor of animal law, and director of UConn's legal practice program. Professor Rubin was instrumental in creating Desmond's law, which allows courts to appoint advocates, law students under supervision in animal cruelty cases. She supervises students and appears in court to advocate for justice in cases of animal cruelty. Former New Jersey State Senator Raymond J. Lesniak is the founder and president of the Lesniak Institute for American Leadership, an organization that strives to develop the next generation of American leaders by teaching and celebrating the principles of effective advocacy. During his 40-year tenure as a legislator in the New Jersey legislature, Senator Lesniak has been a champion for numerous animal protection laws and continues to advocate for pro-animal bills, such as courtroom animal advocacy programs. Senator Lesniak has been a strong proponent of CAP laws for several years after witnessing their successful implementation in Connecticut and is determined to see them enacted in his home state. Thank you all for joining us today. We will begin with a presentation from David.
Thank you, Kathy, and I'm very excited that you've all joined us today to talk about courtroom animal advocate programs and specifically how they operate to enable animals to be represented in court. I want to start by giving you some brief context and a roadmap, because I think it's important to know where speakers are coming from so you know how that informs our perspective. And I imagine you'd like to know what we're going to be doing over the next at least 20 minutes of my portion of the presentation. So I'll start by talking about how I would describe or position my legal work. As you know, I'm a managing attorney with the Animal Legal Defense Fund's Criminal Justice Program. I teach animal law at Lewis and Clark Law School. And when people ask me what all of that means, what I do as an attorney, I find that usually the most direct and clear way to answer is to say I'm effectively a victim rights attorney for animals. I work in the space of where criminal law overlaps with animal law, and specifically around issues where the interest at hand is that of a harmed or victimized animal. And so that's where I'm coming from in this presentation. And that framing is really pertinent to the conversation we are going to have about courtroom animal advocate programs. So what then are our goals for the next 20 minutes of me talking? What are we going to be doing? Well, I'll be talking about what CAPs are and why they're important. The how will come after that. So I'll cover the what and the why. Jessica Rubin, Senator Lesniak will talk about how all of this operates and also how it's coming together in the future politically, what the upcoming landscape and avenues towards enactment of more CAP laws are going to be. So with that, let's begin at the beginning. And I apologize to those of you who are recent 2Ls and are still recovering from your 1L experience. This may sound familiar. Let's start by talking about what is a crime anyway. Because we talk about crimes a lot in our culture. We can flip through channels on television and inevitably find a procedural show somewhere that is all about crime. But we don't often talk about them with intentionality. And it's going to be important that we do so for this conversation. So I want to start by differentiating criminal law from other avenues we as a society have of responding to harm or holding people accountable. There's a difference, of course, between criminal law and tort law, between criminal law and civil fines, or any other way that we have of saying to a person, your actions have caused someone harm, your actions have violated a rule or regulation, and you're going to be held to account for that. Criminal law is something deeper and something really special within our justice system, within our culture. And so one way we can see that is by looking specifically at the types of crimes we have. And I don't mean misdemeanor, felony, I don't mean animal, non-animal, I don't mean where they fall in the code, I mean on a philosophic level, what kind of crimes are we talking about jurisprudentially? And traditionally in criminal law, we split those into two categories. There's malum prohibitum. These are crimes which are illegal, which are criminal, because they are against the rules, not because they necessarily caused any harm in and of themselves. So traffic violations are a great example of malum prohibitum crimes. Speeding faster than the speed limit is not inherently going to hurt anyone. It will if you cause a crash, but the simple fact that you're going over the speed limit doesn't cause harm. It's a crime because we as a society have decided that rule is important enough that breaking the rule is going to be criminal. In contrast are another set of crimes, malum in se crimes. And these are crimes where the conduct in question is criminal because the conduct is inherently wrong. It's not because it's against the rules, it's because there's an inherent wrongness to what's happening. And these are usually crimes that we would describe in less fancy Latin terms as person crimes or victim crimes, in contrast to malum prohibitum, which is often described as a victimless crime. So malum in se would include physical assault. It's wrong because beating other people up is wrong. Murder is wrong because killing someone else is wrong. Ultimately, these are crimes because they involve the person who did them, the perpetrator, treating the harmed individual, the victim, as a means to an end, treating the victim as a means to achieve whatever the perpetrator is looking for. It could be profit in the case of fraud. It could be self-aggrandizement or their own pleasure in the case of crimes of rage, crimes of domination. But ultimately, it's about treating that victim as a thing, as a means, not as a being that has intrinsic value in and of themselves, not as an end in and of themselves. And that's a really important distinction, particularly when we talk about animals, because if you pause for a moment and consider the way we discuss animals in the context of animal law, that criminal framing is going to sound familiar. We spend a lot of time talking about how animals are treated by the law as things. And so looking at animals in criminal law, we'll see that there's space there to start leveraging that apart. I want to close out this discussion of our types of crimes by highlighting one of the purposes of the criminal justice system and the way it responds to crime. And that is, at its heart, a criminal case is not just about preventing future harms or restoring the victim to wholeness, particularly for malum in se crimes. If that's all criminal law was about, we could rely on tort law to make the victim whole. We could rely on civil fines to dissuade the defendant from engaging in this activity in the future. Ultimately, the way to fully understand a criminal case is to realize that, particularly for malum in se crimes, this is about the community standing up and reaffirming that the perpetrator cannot and could not ever reduce that victim to a means, that the victim always is intrinsically valuable, always has importance because they are a creature who matters. And that's a really important concept. Marcus Dubber goes into great detail on that if you're looking for some further reading, but hold that in your mind because we're going to be coming back to that again and again as we talk about animals in criminal law. So the takeaway from this is that a crime is not just something that's wrong. It's not just something that's unlawful. And it's not just something between private parties. It's something that is wrong enough that it deserves a community response. It's something that doesn't just break the rules, but involves a risk of harm or an actual harm that deserves a community response. And it's not just between private parties, it's between parties and the community, the state. But the question that arises from that is whether it's required or preferable that criminal law exclusively be between the state and the defendant. And this is a hard concept for us to get our heads around in modern America because we're so deluged with the idea that criminal law is about the state versus the defendant. Again, think back to your procedural TV shows. We're always hearing theme music and then a description of the criminal justice system being about the defendant and defense attorneys vindicating their rights and the state trying to prove their case, as if there's nothing other than those two parties locked in a zero-sum clash. But that is not how criminal law has always been. It's not how criminal law is, and it's not how criminal law has to be. And we can see that by taking a look at an abbreviated victim-aware timeline of how criminal cases get litigated in the USA. If we look at the colonial, revolutionary era, even backwards into British common law, at that point, typically the government was not involved in a criminal case. If someone committed a crime against you as a victim, you would most usually go out and retain your own private attorney to prosecute that case on your behalf. There was no DA doing that for you in the vast majority of cases. The advantage here is that if you're a victim, you get to have a lot of control of your case. Your attorney will know exactly what you think will make you whole, what kind of response you're looking for, what kind of acknowledgement you're looking for. The downside is if you don't have the resources or the experience, the knowledge, or the social connections to find an attorney to take your case and prosecute the case, you're out of luck. So this is a system that worked out in the colonial and revolutionary era really well for landowning white guys, because those are the people who had the education, the resources, and the connections to make that happen. It did not work out so well for people on the margins of society. And this is part of why, as the American story continues, we see an increasing state takeover of prosecution. Increasingly, that becomes less the province of private attorneys and more the province of public prosecutors who work for the government. And this reaches its zenith in the mid-70s, when essentially crime victims are relegated to the category of being evidence in their own cases. They're not participants, they're simply witnesses. And we see this both in the 1975 Federal Rules of Evidence that really codified the notion that a victim was simply a witness or evidence, and also in 1973's Supreme Court case, Linda R.S. versus Richard D. The short details on that case being that Linda R.S. and Richard D. had a child, although they were not married. The law in Texas at the time made it a crime for an unmarried father not to pay child support to the child's mother, but Richard D. did not want to do that. And the local prosecutor was not interested in prosecuting the case, honestly, because he didn't approve of Linda R.S. having a child out of wedlock and was not interested in helping her and her child get child support. We could have a separate conversation about how uncool and unjust that is. But Linda ultimately argued that as a crime victim, as a person being harmed by a criminal act, surely she had an interest in the law being enforced. This went all the way to the Supreme Court, and the federal Supreme Court said no. Crime victims, in their view, in 1973, had no cognizable interest in having the law enforced, in seeing the protections enshrined in law enacted. But then things started to change, and things started to change for a few reasons. We have, in the late 70s and the early 80s, social justice movements that are looking at how marginalized groups are, despite the public takeover of prosecution, now not getting justice because prosecutors aren't necessarily listening to them, because there's no process for the state to pay attention to the needs of victims. We see this coming out of movements for racial justice, out of the feminist movement, and so forth. Also, in 1981, President Ronald Reagan gets shot, and it turns out that when the President of the United States becomes a crime victim, suddenly crime victim rights take on a whole new significance for the federal system. In 1982, Reagan's Task Force on Crime Victims releases a final special report From 1982 and onward, crime victim rights laws start passing at the federal and state level, and now we come to a point in the 2010s where increasingly crime victim rights are enshrined in statute, enshrined in constitutions, and we're looking at a future where crime victims have a role in the criminal justice system. They are quasi-parties to their cases. Things have really changed from that earlier point. So let's talk about what this means for animals. Let's talk first about what kind of crime animal cruelty is. And this goes to why modern animal cruelty law exists. When we think about it, the only way to explain modern animal cruelty law is by looking at it as having the purpose of protecting the animals themselves. Yes, part of cruelty law is about protecting property. If someone kills your dog, you have an interest in seeing your injury vindicated, in seeing the fact that your beloved animal has been killed, addressed by the court. But animal cruelty law also makes it illegal for you to kill your own dog. And so it can't just be about your property, it's about the animal themselves. In other words, animal cruelty is properly seen as malum in se. The reason we make animal cruelty illegal is not just because we're worried about property, it's not just because we're worried about public sensibilities, it's because we as a society have decided animals are living creatures, they have experiences, they suffer when they are hurt, and they shouldn't be treated in that fashion. Do animal cruelty cases pose unique challenges and complexities? Absolutely, we know this. Animal cruelty cases are unique insofar as they involve living, moving, reproducing, and changing creatures that are unable to speak up for themselves and don't have clear avenues of legal representation. Animals can't be treated the same way other types of property are in criminal cases. You can't simply throw an animal in an evidence locker and come back months later. You'll have a dead animal at the end of the day. How does the law position animals within cruelty litigation? In many ways, currently, animals occupy the position that human crime victims did in the mid-70s. Animals are, in many ways, evidence in their own crimes and only rarely recognized in very specific circumstances as crime victims. But we know that even if they don't occupy the legal status of crime victims, we know animals are victimized by crime. And we know that the reason those crimes exist, the reason animal cruelty is criminal, is because we want to protect those animals. And finally, do animal victims have legal interests that fall outside the duty of the prosecution and the defense? Yes, they do. Our entire criminal justice system is predicated on the notion, as is our larger justice system, that if we put attorneys in a room and have them zealously advocate for their clients, we get better outcomes. We get more informed outcomes. The reason that works is because each of those attorneys has a specific duty and a specific job that they are expected to zealously pursue. But there are interests animals have who fall outside those specific duties and jobs. It is not, for example, the job of a prosecutor or a defense attorney or a judge to figure out where an animal is living pending trial, or whether that animal is getting appropriate socialization, veterinary care, housing, and so forth. It is not the job of a defense attorney or a prosecutor to figure out what to do when the animal victim in a case has a litter of kittens. It's not the job of the prosecutor, the defense attorney, or the judge to look into what kind of victim restitution an animal might need in a sentencing package. Now, that's not to say that there aren't prosecutors, judges, and even defense attorneys out there doing that kind of good work right now. But I want to be clear, those lawyers are going above and beyond their duties. And that's not something every attorney is doing, or even most attorneys do. And it's definitely not the way our system is meant to work. Again, our system is predicated on the notion that as attorneys, we show up and we do our jobs. We zealously advocate for our clients, and that gives the court a more complete picture and gets us more justice. And that implies the need for courtroom animal advocate programs. It implies a need on the behalf of animals to have legal advocacy, And it's important that advocacy is legal because the person doing this needs to have knowledge of the relevant legal minutiae and mechanisms. They need to know how forfeiture law works. They need to know how neglect statutes relate to wildlife statutes. And that person needs the ability to draft and file legal instruments as and when that's needed. It's important that we delineate and distinguish the scope of that advocacy. Again, this is about attorneys coming to court and pursuing their duty. So it's important to delineate what an advocate does from the prosecution and the defense. This is something different. This is someone speaking for the animal and ultimately someone reporting to the judge in that fashion. And it's important that we build a consistent and normalized approach. If this is a one-off that happens once in a blue moon, we're not going to get the kind of consistent outcomes that produce constant and equitable justice. We need this to be a normalized option within our justice system, and that means we need a program to do it, and we need a structure that this can operate in. And that is a courtroom animal advocate program. You may be wondering, is there a precedent for this? Is there any indication that this would work, that it would work to have judges appointing attorneys to represent the interests of animals, to do legal work, and give courts, prosecutors, and defense attorneys more complete pictures of where the animals are and what their legal needs are? The answer, fortunately, is yes. And a great example of this, a precursor to cap laws themselves, is the delightfully named United States versus approximately 53 pit bull dogs. In this case, which was the civil companion to the Michael Vick dogfighting criminal trial, the federal government found themselves in legal possession of 53 ex-fighting dogs. And the federal government wondered, what do we do with them? The standard up until this point was that fighting dogs were euthanized. The assumption was they were irreparably damaged. But this is the federal government. And for those of you who have been in federal court, you know they have a lot more resources than state courts. And the federal judge in this case thought, well, I'll use some of these resources to try to get an answer to this question. And the judge appointed Professor Rebecca Huss, who you can see there with one of the dogs, as the guardian special master in this case. And that's a legal term that just means she reported to the judge, she was appointed by the judge, and she answers to the judge to specifically undertake a task. And that task was to find behavioral experts who could do evaluations of each individual dog, to set interim care for each dog, and to recommend the final disposition of each dog. So to say for each dog, this is what this individual victim needs. And that need will be met either by adoption, behavioral work, life in a rescue, or for 3 of the dogs, 2 for physical reasons, 1 for mental health reasons, the kindest thing for them turned out to be euthanasia. And the results here were huge, not just for those 53 dogs, but really for the way the world reacts to fighting dogs. Again, up until this point, the default was just to kill fighting animals. After this point, people realized those animals are victims. They are not the aggressors. They are not perpetrators. They are victims who can be made whole, victims who can experience restorative justice and have their harms remedied, and who could go on to live good, happy lives. And so from that, we're going to shortly get to the how of this in Professor Rubin and Senator Lesniak's portions, but I want to give you a quick rundown of the basic contours of a cap law. The way this works in basic is that we have pro bono attorneys or appropriately qualified law students who are appointed by and answer to a judge. Typically in a criminal case, there are a few states that are considering non-criminal options. But again, if you think about why animals need advocacy, it's because they have a separate interest than the prosecution or the defense. So this doesn't apply in a civil case where someone is bringing a lawsuit on behalf of an animal. Maybe it would apply in a divorce hearing where you have 2 parties who aren't the animal, but by and large, we're almost entirely talking about criminal cases. Maybe divorce, maybe dangerous dog hearings. We'll see how that develops in the future. The appointed attorney or state qualified law student is providing legal advocacy for the interests of the animal and the interests of justice. And in doing all of this, they are, of course, governed by the standard rules of professional ethics in their jurisdiction. So a quick case study of how this might work. This is a case that I was involved in that didn't have a CAP advocate. This is Belladonna Lugosi. Belladonna was seized pursuant to a cruelty investigation. Her defendant owner was not taken into custody and ultimately fled the state before a trial could conclude, and Bella remained in government custody. The government wasn't going to hunt this person down and extradite them over a minor animal cruelty case. The defense attorney, it wasn't their job to figure out what to do with Bella. It wasn't the prosecutor's job to figure out what to do with Bella. It wasn't the city attorney's job to figure out what to do with Bella. So she just sat in a city kennel for weeks, for months. Eventually, some volunteers at that kennel got in touch with the Animal Legal Defense Fund, filled me on the case, and I was able to dig up the appropriate statutes, get in touch with one of the local government attorneys, and put together the legal motion to have her released as an abandoned animal. And writing that motion up took me a few hours. And she ultimately was released on Valentine's Day. You can see in that photo her getting out of lockup after she'd spent approximately 10 months in the kennel. But the tragedy is she shouldn't have had to spend that much time there. If she had an advocate, she could have gotten out within 2 weeks, which is the statutory requirement. And we know that no matter how good care an animal gets in kennel, we know that is not an environment where animals thrive. We know, especially for young dogs, and Bella was just a puppy when she went in, time in that environment makes it harder for them to socialize, and ultimately it makes it harder for them to get adopted and go into good homes. So while Bella ended up going to a rescue that did great rehabilitation work with her, and eventually she was able to go into a loving home, I wish she had an advocate in that case, because there would have been someone whose job it was to look out for her and do that advocacy. And I want to be clear, it wasn't the fault of anyone in this case that Bella spent that much time locked up. It just wasn't anyone's job, and no one had the specific training or knowledge to take that on. And our entire legal system operates on the assumption that people do their jobs and they have the knowledge to meet the demands of that job. And currently, animals don't have attorneys flagged as being in their corner who fit that bill. So I want to wrap up by talking about a few things advocates do and don't do, because I think this deals with a lot of questions you may have at this point. Advocates do answer to the court. Advocates do not perform roles in investigation. Advocates are appointed after the police do the investigation. Advocates do provide information and recommendations to all parties in a case. They are not affiliated with the prosecution or the defense. Again, they work for the judge. Their job is to inform everybody. They do meet legal needs beyond those of the prosecution and the defense. They don't constrain the prosecution or the defense. An advocate can't overrule the prosecutor, cannot overrule the defendant, cannot tell the prosecution or the defense how to do their jobs. They are simply a voice advocating for the animal and doing legal work for the animal. They don't argue for conviction or acquittal. That's the job of the prosecution or the defense. They argue for the animal's interests and the interests of justice. And in doing so, they don't prioritize their personal interests over those of the animal. And that's a line that we as attorneys are very good at following. All of us have to put our clients' interests, or in this case, our quasi-clients' interests, above our personal interests. And if we can't do that as attorneys, we have no business being in the profession. If we can't hew to that ethical line, we could all pack up our law books and go home, because our entire system won't work. And finally, advocates enhance the framework for attorney public service and law student experiential learning. This is a great way for attorneys and law students to expand their experience and give back to the community, and in particular to give back to animals who are part of our community and who particularly need this assistance. But advocates don't change the underlying law. Advocates don't change what cruelty law makes criminal or doesn't make criminal. If you want to do that, you'll need to call your local lawmaker and pass a different kind of bill. With that, I thank you for your time, and I'm going to turn things over to Jessica Rubin so she can talk to you about the how of CAP programs and CAP laws now that you've heard about the why.
Thank you so much, David and Kathy, and thank you to ALDF for hosting this wonderful conference and inviting me to be part of it. I'm so happy to join David Rosengard and Senator Lesniak on this panel, and I plan to explain Connecticut's CAP, which is called Desmond's Law, including its creation, implementation, and use. So first, I want to talk about how we got here. What factors allowed the creation of Desmond's Law in Connecticut? It really was a perfect but tragic storm. So first, in the field of sociology, over the last 2 decades, there's been increasing acceptance of the idea that animals experience pain, suffering, and complex emotions. Second, in the field of criminal justice, much has been written on the co-occurrence of violence to animals and violence to humans. Within the legal education field, the American Bar Association and the American Association of Law Schools has increased the requirements for law schools to provide experiential learning opportunities to students. Within Connecticut, we have long-standing data that showed that over 80% of animal cruelty cases were dropped or dismissed, which shows that although we have animal cruelty laws, they were not being vigorously enforced. Desmond's case was really the tragic spark that united animal activists with legislators. Desmond was a dog who was horribly abused and eventually killed. Desmond's owner was not tried and was not sentenced for animal cruelty. This case, as I said, sparked interest in animal cruelty cases and showed us that courts needed help and courts needed a push. We then drafted a bill to provide advocates for courts in cases like Desmond's. The legislative process that gave rise to Desmond's Law required that the bill be introduced 3 times, which really underscores the need for collaboration, passion, and credibility in the legislative process. And I know Senator Lesniak will talk about that. Through the legislative process, we discussed and negotiated several important issues and reached compromises that allowed us to continue with our drafting of the legislation. Some of these issues included which animals would be covered by Desmond's Law. Second, which interests an advocate would present to the court. 2 options were, should they be the interests of the animal victim, or should the advocate present broader categories of interests, including the interests of justice more generally? A third issue that was debated was what qualifications we should require of advocates, and what process should we use to manage advocate appointment. A final issue with which we struggled was whether or not appointment of advocates should be mandatory or permissive. As we worked through these issues, the language of the bill coalesced, and as I said, we introduced it 3 times before it actually passed. Desmond's Law was passed by the Connecticut legislature in May of 2016 and went into effect in October of 2016. After Desmond's Law went into effect, I focused on how best to implement the law. And my first focus was the courts. I advertised Desmond's Law to our courts, explaining to them what an advocate was and how an advocate can help in a case. I then met with court personnel to do the same and get them comfortable with the law. After that, I shifted my focus to the student experience and gave thought to how best students could serve the role of advocates. First, not knowing how many cases we would have under Desmond's Law, I ran it as just an independent project for 1 or 2 students. But very quickly, it became apparent that we would have a steady flow of a lot of cases. And it also was clear to me that our students needed a classroom component to train them on how to best serve as advocates. And so I created the Animal Law Clinic at UConn, through which our students serve as advocates under Desmond's law. Now, our clinic experience has 3 components for students. The first is we place our students in court under supervision, and we now have a teaching fellow, Tara Cooley, and the 2 of us supervise students and bring them to court where they serve as advocates. The second component of the clinic is that each student conducts research and writes a research paper over the course of the semester on a topic related to CAPS, or Desmond's law. And the final component of our clinic is a classroom component in which students are trained on pretrial criminal procedure in Connecticut state courts. In addition, through the classroom component, we study animal cruelty cases from a wide range of perspectives, including veterinary science, forensic science, prosecution, defense, probation services, and shelter medicine. So we have a true appreciation of the arc of an animal cruelty case, from investigation all the way to the end where an animal might land. Moving on then to the advocate's role. You may be wondering, what does an advocate actually do in a case? And the advocate's role really stretches the entire life of the case. So at the inception of a case, the advocate would review the police report and arrest warrant, and might review the prosecutor's charges and offer an opinion on whether those charges feel appropriate. The advocate can then continue to speak with an animal control officer, which is our state position for law enforcement personnel, and or veterinarians. And they can gather supplemental facts and can offer those facts to courts along with offering recommendations. Those recommendations could apply to a defendant's application to use a diversionary program rather than facing a trial in a case, and an advocate might offer a recommendation as to whether or not a court should grant a defendant's application to use a diversionary program. Advocates can also participate in plea bargain negotiations and offer recommendations to the court as to appropriate components of a plea bargain sentence. Advocates can also help to resolve issues of ownership, possession, and protection of victim animals and other animals associated with the defendant. So this can happen early in a case. An advocate can facilitate a defendant's relinquishment of a victim animal if still alive, and other animals if they come in contact with a defendant. An advocate can also facilitate the issuance by the court of a protective order or no contact order, ensuring that a defendant during the course of the case doesn't return to owning animals, living with animals, or having interactions with animals. That's an important contribution that an advocate can bring to a case that is not typically implemented at the early portion of a case. As a case comes to trial, the advocate's final role could be to offer a victim impact statement to the judge or jury that articulates what that animal experienced as a victim. And so the advocate really has a role to play through the entire life of a case, and I hope this clarifies the value that an advocate can bring. So I'd like to next give you some examples of that value from the specific cases that we've handled. So this was an early case under Desmond's law in which a defendant was charged with cruelty to 8 dogs. The dogs were seized by the municipality, but not yet owned by the municipality, which meant that they could not go on to live new lives. They could not be rehomed because they were still owned by the defendant, yet possessed by the municipality. In this case, the defendant claimed to own the dogs. And we argued, number one, that the defendant did not own the dogs because the defendant abandoned them as property. And second, we contested the evidence that the defendant offered of ownership because the bills of sale that he offered regarding the dogs were not verified. In fact, when he offered them to the court, my student ran out into the hallway, did a quick Google search, and reported back to me that the bills of sales that were offered were the first image that came up if you did a Google search, dog bill of sale. So the court agreed with both of our arguments, and the dogs were released to foster homes that same day. And so this case provides a great example of what an advocate can do in a case, and that is early intervention to quickly resolve the fate of animals. A second example of the value that an advocate can bring occurred in the same case later on, when the defendant applied to use a diversionary program rather than go to trial. In support of the application for the diversionary program, the defendant submitted thank you letters addressed to him from 3 animal charities, thanking him for his donations. We researched those letters and found that they were falsified, and the court denied the defendant's application to use the diversionary program because of the falsified letters and because of the seriousness of the offenses charged in the case. A third and final example of the value that an advocate can bring occurred in a case in which there were hundreds of pages of handwritten reports spanning 20 years. And in this case, we had a problem of coordination and communication between the state and town animal control officers. Both had investigated this defendant. There were very unclear records, very voluminous records, and nobody could digest or take the time to make sense of the records. The advocate came into the case, assembled a timeline, digested the records to show that even though any one incident of cruelty was not compelling, over 20 years there was such a compelling pattern and long-standing pattern of cruelty that it was sufficient to convince our state attorney general to proceed with forfeiture proceedings to seize the animals and resolve ownership of them, and to convince our state attorney to continue with a cruelty case. So I hope those 3 examples are interesting and illustrative to show you what an advocate can do in a case. I'd like to now step back for a moment and talk about some kind of evaluation of Desmond's law and how it's being used in our state. So right now, I'm researching what, if any, impact an advocate can have on a case. So I'm engaged in quantitative research, reviewing cases both before and after Desmond's law, and cases with and without advocates to assess what impact an advocate might have on the duration of a case and outcomes of cases, including sentencing features and use of programs. I hope to conclude this research this year and be able to share the results in the spring. In addition, qualitative research. I'm gathering impressions of judges who have used Desmond's law to find out what they found helpful, what they don't like about it, and again, I hope to be able to share that information this spring. I would like to share just some preliminary basic data with you that shows in Connecticut, since Desmond's law went into effect in late 2016, courts have appointed advocates in 81 cases. I often remind my students that change in the legal system happens slowly, very gradually, and to see numbers like this over just 5 years, to me, is very encouraging and makes me hopeful that CAPS will be embraced not only in Connecticut's judicial system, but across the country. So I'd like to talk a little bit about our programming and what I see in the future of CAPS and Desmond's law. So in Connecticut, our programming under Desmond's law includes advocate training, right? As I mentioned, bringing on board both students and volunteer lawyers and training them on best practices for being an advocate under Desmond's law. It also involves offering forensic training to law enforcement personnel. And it also will involve a program to help courts assess cruelty offenders and develop treatment programs for them. We've also included court-related programming, offering education programs to court personnel so that they get comfortable with a CAP, like Desmond's law. Looking to the future, what's on the horizon, for me, it's exciting to contemplate where CAPS might go. I hope that Desmond's law and future CAPS are expanded to include not just cruelty cases involving dogs and cats, but cruelty cases involving all animals. I hope that Desmond's law can motivate other states, and ALDF can motivate other states to enact similar caps. And it's exciting and intriguing to think about how an advocate could be used in a civil case. So I think there's a lot of exciting growth potential on the horizon of caps. Caps, more generally, provide wonderful opportunities for collaboration among law enforcement personnel, law students, and animal activists. This slide shows the three parties coming together at a conference, and it's a really wonderful thing to see each person to contribute their expertise to best triage and work on a cruelty case. Caps can improve the way cases are handled by courts. As David mentioned, these cases are complex and unique because the victims are legal property, but they're property that is sentient with attendant needs. And because of those complexities, having an advocate helps a court to navigate those complex issues. In sum, Desmond's law and caps more generally provide practical, concrete, and achievable steps to give voice to animals in courts. So thank you so much, and I look forward to conversation after the panel.
Thank you, Catherine. I'm honored to be asked to speak today about protecting animals from cruelty and promoting local, state, and federal laws to advance animal-friendly legislation. Pope Francis said, "Our indifference or cruelty towards fellow creatures of this world, sooner or later, affects the treatment we mete out to other human beings." Animal advocates are not only protecting animals from cruelty, they're also protecting human beings from the violence of those who are cruel to animals. Animal advocates in states that enact courtroom animal advocacy laws are also advancing the morality of society. As Mahatma Gandhi said, "The greatness of a nation and its moral progress can be judged by the way its animals are treated." New Jersey has been in the forefront of many animal-friendly laws. We were the first state to ban transactions in ivory and rhino horns to help curtail the slaughter and extinction of these magnificent animals. We banned the import into the state and transportation through the state of so-called trophies of endangered species. And we were the first state to ban wild animals from performing in circuses. We banned transportation through the state of horses going to slaughterhouses. We also made dogfighting a RICO offense, so everyone participating in a dogfighting ring can be criminally prosecuted. Recently, we banned animal testing for cosmetic products. Governor Murphy has announced there will be no more bear hunts under his administration. We're working on a non-lethal comprehensive black bear management plan to permanently end the slaughter of black bears and their cubs. Sadly, New Jersey stands just with Alaska in permitting killing of baby cubs. Governor Murphy also signed legislation banning the cruel practice of shark finning, which was held up in previous legislative sessions because of opposition from the commercial fishing industry. We're working on, as California has already done, banning the sale of products made from kangaroo skin. Millions of kangaroos and their joeys, the babies in their pouches, are slaughtered every year to make soccer shoes. Banning the sale of dogs through notorious puppy mills is also on our agenda, along with establishing a fund to provide trap, neuter, vaccination, and release programs for community cats. My effort to ban gestation crates was vetoed by Governor Christie, who was running in the Republican primary for president, and the first election was in Iowa. the #1 pork-producing state in the nation. Karma got Christie for his veto, as he received only 2% of the vote. Christie later on signed our ban on transactions of ivory and rhino horns, demonstrating how framing the issue is important in getting legislation passed and signed into law. In this case, Governor Christie signed the ban because we showed how the poaching of elephants and rhinos was helping fund terrorist organizations. In Africa, the LRA, the Lord's Resistance Army, and the Yayawi Arab Militia of Sudan have butchered thousands of elephants in South Sudan, the Congo, Cameroon, Chad, and the Central African Republic. The Muslim Salika rebels in the Central African Republic, which include armed fighters from the Sudan, have similarly used poaching to fund their terrorist operations. If we appeal to the concern that these magnificent animals were in danger of extinction as a result of the poaching, we likely would have gotten just another veto, as the NRA, antique shops, and piano repair stores opposed the ban. But by framing the issue in a way that would get the governor's attention, that it would be stopping fundraising from terrorist organizations, we got it done. Now, the New Jersey-New York Port Harbor is second only to China in importing ivory and rhino horns. Perhaps, under New York's new governor, Kathy Hochul, we can get New York to ban their import as well. Our current effort to ban gestation crates, including veal crates, is being held up in the legislature, as is today's core subject, courtroom animal advocacy legislation. Politics getting in the way of good legislation, as was the case with Governor Christie's veto of our gestation crate ban, is not a partisan affliction. In New Jersey, where Democrats control both houses of the legislature, our gestation crate ban is being held up because of opposition from the Farm Bureau. The entire legislature is up for election this year, and legislation deemed to be controversial is being held until after the November election, despite its overwhelming support by the public. I expect our crate ban to be passed by the legislature and signed into law after the November election. In the case of cap legislation, the opposition is not partisan or political. The Speaker of the Assembly, Craig Coughlin, is an attorney who is concerned that animal advocates will clog up the courts. So our challenge is to challenge the notion that animal advocacy will clog up the legal system. The Connecticut experience should be sufficient to overcome that objection, along with advocacy by animal-friendly legislators, organizations, and the public. Our cap legislation does more than authorize an advocate for the animal in animal cruelty cases. It establishes precedent in its findings and declarations, which state that animals are sentient beings capable of experiencing pain, stress, and fear, and that is the policy of New Jersey. In order to protect animals from experiencing pain, stress, or fear, it's important that animals are treated humanely. Under our legislation, animals shall be considered the victims of animal cruelty crimes and shall be treated as such in a court of law. Currently, animals are treated as property, like a chair, which can be punched and discarded without regard to any impact on it. Stating that animals are sentient beings capable of experiencing pain, stress, and fear will change that approach in our entire legal system. In the not too distant future, our declaration that animals are sentient beings will be cited to support other animal protection measures. New Jersey's legislation also goes beyond Connecticut's by applying it to all animal cruelty cases, not just dogs and cats. It will be groundbreaking legislation when signed into law. In anticipation of our cap legislation becoming law, I have obtained requests from 32 lawyers to volunteer to be appointed by the court to represent the best interest of and justice for the animal. When signed into law, this number of animal advocates will increase exponentially and will include law students who will get valuable courtroom experience. Unfortunately, the legal clinics of Rutgers Law School and Seton Hall Law School had not taken a position on this legislation. There are approximately 800 animal cruelty cases a year in our municipal and superior courts. I have no doubt we will have plenty of volunteers to advocate in court on behalf of animals. I've only scratched the surface of our New Jersey initiatives to treat animals humanely. We also have initiatives to ban killings of deer and geese, to ban killing contests, to provide a retirement sanctuary for racehorses. To achieve these goals, we have put together more than 50 animal-friendly organizations to spread the word to their members, to take action, write emails, make telephone calls, write letters to the editor of newspapers, meet with their legislators, ask their legislators to co-sponsor our legislation, show up and ask questions at town hall meetings. Signing a petition is good, but legislators react more to personal contacts than a name on a petition. We can be the change that will transform America and the world to recognize that animals are our fellow creatures and inhabitants on Earth.
Okay, thank you so much, David, Professor Rubin, and Senator Lesniak. We will now begin the Q&A portion with our speakers. And we do have quite a few questions already in the queue. Professor Rubin, I would like to begin with you. First and foremost, thank you for your efforts to enact Desmond's Law, which has led us here to this presentation today. The question is, if law schools do not supply student volunteers, how will a steady and reliable stream of volunteers be generated, and who would provide the training?
Sure. So I'm going to answer your question in three parts. The first is who would serve. And there are two options. Students can serve and or volunteer lawyers can serve. In Connecticut, we have a hybrid system. Our statute allows either students or volunteer lawyers. New Jersey, as Senator Lesniak just described, has a long list of lawyers waiting to serve. In my opinion, a cap works best when lawyers local to a particular courthouse volunteer to serve because they're familiar with the procedures in that courthouse. They're well regarded, hopefully. And so I really think that there are benefits to both lawyers and students serving as advocates. The second question that comes up with the administration or implementation of a cap is who will administer the program? And again, I see options. It can be administered by a bar association, especially if a state bar association has an animal law section. A state ag agency or environmental agency can also administer a cap. An animal protection organization can administer a cap, like Maine Friends of Animals will do. Ideally, I hope that caps reach the point where a dedicated office within each state judicial branch could administer a cap. But again, that ideal model costs money. The final implementation issue, I talked about who would serve, who would administer. The last question is who would train. And here we, again, have options. A law school could train caps. A national organization or national think tank could train caps. A bar association, again, especially with an animal law section, could train caps. And finally, my goal is to provide a guide for advocates, including resources, forms to be used in each state. So hopefully that will be a good, useful resource to serve as an advocate in any state.
So in New Jersey, when we do get this law, and I'm convinced we will, it will be administered by the Administrative Office of the Courts and by the Supreme Court. That's our system. And again, unfortunately, our clinics at Rutgers and Seton Hall, they said, well, we would be interested if you provide us the funding. So I'm not sure if that's going to go down. But as Jessica said, we have plenty of lawyers ready, willing, and not only able, but anxious to serve. And lastly, what was the last point? Oh, yes, the training. Well, we already have a mandatory, as all states have mandatory continuing continual legal education requirements, and that's certainly working with the Bar Association. Will be implemented through the Bar Association of the state of New Jersey.
On that note, and I think Jessica Rubin alluded to this, once a state sets whatever threshold they have for how advocates should be trained, for what what information advocates need to have before they engage in that representational work. The good news is there are organizations out there, such as ALDF and others, that can help meet that need. I and my colleagues, we already come to people's states and do CLE presentations. Certainly do those around cap trading. We've got the resources to make that happen, as do other organizations. So I think that's a issue that we already have systems to solve.
Wonderful. Thank you all. David, this next question is for you. In certain circumstances, as with the case of Belladonna Lugosi, could it be said that a cap law might also save taxpayer dollars by expediting the disposition of an animal?
Certainly. And I'm pleased that as we near Halloween, we could talk about Belladonna Lugosi's case. Bela Lugosi, of course, being famous for playing Dracula. In any case, so yeah, part of what's going on with Belladonna's case is the whole time she's sitting in kennel, someone has to pay for her care. It would be illegal for the county where she was living to just leave her there without food, without water, without veterinary services. Then they would be for committing animal neglect. And so there's a drain on the system there, and a drain that could have been cut short if she had been able to be adopted out to a permanent home earlier. And so I think there's a cost saving on that level. There's also, in terms of costs, and I know this was a question that got asked in chat, there's an issue regarding who pays for the actual attorney advocacy, the representation from a volunteer attorney or a sort of supervised law student. The answer there is it's a pro bono service. So the local city, the local county, the state doesn't end up paying for that. Unfortunately, the models we've seen through the work that Jessica Rubin's done and are that there is sufficient attorney and law student interest to meet that. Senator Lesniak's also discussed how he's heard from enough attorneys to indicate there's a groundswell of that, and that's in line with what our profession expects. Part of being an attorney is the notion that we are anticipated to do a certain level of pro bono service, and this is the kind of pro bono service that is attractive to a lot of attorneys and law students.
So true. Senator Lesniak, we have a two-part question for you. There were cap bills introduced in states such as New York, New Jersey, Florida, Nevada, Illinois, and additional states are preparing to introduce bills next year. Could you provide advice for individuals who have interest in introducing a cap bill in their state? And the second part, which I can remind you of if you need later, is that you had mentioned a few ways that individuals can support the movement of legislation. I guess once it is introduced, is there one must-do action that you would recommend to help pass a cap bill?
Well, a must-do is in passing any type of legislation is to get a champion or champions behind it, because legislators traditionally will introduce hundreds of bills, but they only really care about a handful of bills. So it's very important that your sponsors really care about that bill so that they will drive it home to the finish line. That would be number one. And as I said in my presentation, the personal contact with legislators, as you have done with regard to our gestation crate law, is the most significant. Letters from outside the district, we don't care about. Letters from our constituents, we pay attention. Telephone calls from our constituents, we pay attention. Visits to our legislative office, we pay attention. If we have town hall meetings, showing up, saying where we live, we pay attention. So that's how to get it done.
Great. So it's that local action that
Right.
really counts, really makes a difference. Thank you. And Professor Rubin, I hope you don't mind if I segue right into perhaps what were some of the arguments that you heard in Connecticut against this cap law?
So during our legislative process, and I should note that our bill was introduced 3 times before it passed successfully. The 2 main arguments that we heard were first that Desmond's law would create standing for animals, and second, that Desmond's law would interfere with an owner's ability to do what they pleased with an animal. And with respect to the first argument, standing, a cap does not create standing for an animal. What it does do is sensitize a court to the idea that an animal victim is a sentient being with its own needs and interests, as David so clearly explained. And so while not creating standing for an animal, a cap does sensitize a court and get a court considering the animal victim's experience. With respect to the second argument that we heard, that a cap would interfere with an owner's abilities to do as they please with their animal, a cap law does not change that. We have our animal cruelty statutes, and those are the statutes that already restrict an owner's ability to do what they please with animals. Even though animals are property, the animal cruelty statutes prevent owners from doing certain things with their property. A cap law does not change that calculus. It simply ensures that those animal cruelty laws already existing are properly used.
In New Jersey, the issue that's being raised is that the cap law will clog up the courts. And if I dismiss that argument by saying, well, whether they clog up the courts or not, this is the right thing to do to protect the animal in the interest of justice, I would get nowhere. You have to address that specific concern. So we will show Jessica's examples in Connecticut how the contrary is true. And again, that's how to get the right message across, and I think we'll be able to do that.
A concern we've heard in some other states and in broader discussions around this, I think really relates to people misunderstanding the role of an advocate. We have heard in various conversations people conflating advocacy with backup defense attorney or baby prosecutor, and neither of that's the case. So sometimes people will have concerns about cap laws along the lines of, will this add someone to those sides? Will it unbalance those sides? And I get that this is a difficult thing to wrap our heads around because we're used to thinking about criminal cases as only having those 2 parties. And so if that's your framework, any change could upset that apple cart. But I would really encourage everyone to realize that these attorneys are not working for the prosecution. They're not working for the defense. They're doing something fundamentally different. And so it's not about imbalancing those sides. And we've seen empirically, every state in the nation has human crime and victim rights attorneys. It hasn't brought the system to its knees. It hasn't imbalanced prosecution or defense because those attorneys are doing something fundamentally different.
By the way, that's a very good point. And there's a book written, I don't know by whom, making the point that these animal advocates will create more incarceration, in mass incarceration. Totally false, not true, which has been debunked by Professor Rubin very carefully and thoroughly.
Yes. Another question that we have is, David, I'm going to throw this one at you, even though I'm sure others can also answer this. The case examples noted in this very interesting talk all appear to involve offenders who owned or claimed ownership in the victim animal at the time of the offense. Are there any example cases where an animal advocate was used in a prosecution where the offender did not own or possess the victim animal?
Sure, and I'll give a brief answer, and then I'll toss it over to Jessica Rubin, as she may have some specific examples, potentially from her practice. I can give examples of places where those advocates would have been useful. Again, there are a few places where we have an active program in place to empirically look at the way it works in practice. But an example I can give you is a case I was involved in a few years back. And the short version here is that the defendant was a friend of a family, was living with that family, and the family noticed that their family cat, their beloved feline house cat, started acting really weird. This was a cat that had been really friendly, cuddly, and suddenly started avoiding everyone and acting very negatively. They suspected their house guest might have been responsible. They got one of these teddy bear nanny cams, put it in the house, and discovered that the house guest who became the defendant was engaged in some eroticized abuse of the animal. The rub here was, when it came to trial, the animal didn't suffer significant physical injury. The animal's injuries were largely mental and emotional, and the state where this took place in had a statute that defined cruelty largely in terms of physical harm. And so while a guilty verdict resulted, the family who owned the animal and the family who was living with this cat and felt terrible about the way the cat had experienced this was having difficulty figuring out how to explain for the judge what actually happened. And the prosecutor was having frustration with this as well. A way that a CAP could help this is CAP attorneys are explicitly authorized, among the things that the judge can have them do, is provide the court with victim impact information at sentencing. So it wouldn't just be about how did that physical element of the crime take place, but about this cat has been subject to mental, psychological harm. An animal behavioralist could do great work in terms of restoring this cat to health. That could be part of a sentencing restitution package. And so I think that's a good example of a place where, even with someone else owning the animal, and even with those people and the prosecutor wanting to do the right thing, because these are complex, technical legal questions, it would be great to have a specialist involved who could come into court and make that argument on behalf of the animal.
So I have 3 quick points to make in response to this question. The first is that ownership is not always so clear in these cases. We have cases where, somebody stepped out and left somebody else in charge, and, the court struggles with issues of who's culpable in those cases. So the first point I want to make is that ownership is not so clear, and in fact, an advocate can help the court resolve those questions. The second point is we have many cases in which a family member, a domestic partner, or a visiting friend, as David said, is the one who's inflicted the abuse. And so, yes, it's not always the owner who is the defendant. And the third point I want to make is eventually, my hope is that CAPs grow beyond companion animals to be used in, with animals used for food. And so in those cases, I would like to see a CAP step in to help in cases where there's not a clear owner of a companion animal.
Excellent points. And we hope for that as well. Thank you again to our speakers, and we hope that you enjoy the rest of your day.
Thank you, Catherine.
Thanks, everyone.